Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. In this particular episode, I'd like to talk about essentially why you cannot use a durable power of attorney to create a living trust. This sort of came up from a consult that I had the other day, where essentially somebody called up and said, um, I have a durable power of attorney, and I want to create a living trust for my mother. Can you do that, and how much do you charge? Well, right away when he had told me this, I said, well. Um, does your mom have something wrong with her as far as either dementia or something like that that prevents her from creating her own living trust? And is there somebody that is essentially fighting for the property upon which you want to get in the living trust? And sure enough, the answer was yes. His mother had dementia, didn't really understand too much. It was fairly bad dementia. And two, the person who had the durable power, and he was the son, the only son who was going to get the property. And three, the cousin or some other family member who wasn't a son or a daughter, was fighting to get the property. So all that right off the bat, I was able to tell essentially because of the question itself. Now, when someone has a durable power of attorney, that is meant to, do the financial decisions. It is meant to write the checks of the mortgage. It is meant to be able to get information from the banks, when there's certain issues and so forth. That's the purpose of the durable power of attorney, to make sure that things don't go late, they don't go under, things like that. A durable power of attorney does not give somebody the right to create a living trust for someone else, especially because the living trust itself, one of the biggest requirements of a living trust is that the person who's making the living trust must have testamentary capacity. What that means, more or less, is they must know what they're doing. They must know, number one, what a living trust is. They don't have to know all the details like an estate attorney would, but they have to essentially know what a living trust is. They have to know they're creating it, and they have to know essentially who they're giving what. Okay, so and just so you know, the burden for proving testamentary capacity is less than for many other things. I mean, you may not have testamentary capacity, for example, to be able to take a test or drive or do 1,000 other things, and you might have testamentary capacity to make a living trust. Okay? I mean, if the person making the living trust knows, basically they are creating some document in which to give, their house to their son when they die. Okay? If they know that, then they could probably be shown to have sufficient testamentary capacity. But they can't delegate that to somebody else. They can't say to, their son, go ahead and make me a living trust and give whoever you want whatever you want. Okay, it doesn't work like that. And especially if they have dementia and they don't understand what's going on, I mean, the person making the living trust could do anything they want and say, okay, here's your living trust. By the way, I'm getting everything. Nobody else is getting nothing. Okay? And so, that was another thing. The person who had called me was the only beneficiary, would have been the only beneficiary of the living trust. That smacks of undue influence, okay, of possible fraud. There's all kinds of stuff that goes on. So the purposes of why a durable power of attorney needs to be used for the purpose it was intended, not to try to get out of some family dispute of who's going to get what and try to make it seem like the person who has dementia gave authority to do that. Well, a good lesson for this is, as you can see, all the stuff that's going to happen. And I mean, I can take care of the case. There's things that can be done and so forth. But the lesson to be learned here is do your living trust before you have stuff wrong with you, okay? Especially dementia. Um, no, people think all the time nothing's going to happen, or it's not going to happen for another 50 years, whatever. If you take care of it, especially when you're younger, nobody's going to be able to say you didn't know what you were doing, or you didn't understand what you were doing. Nobody, because you're fully coherent, you're young, you're able to do what you need to do. So get that load off your mind, get it done, and you'll be able to not have to worry about what so many of the people who call me do have to worry about, and that's when they're, you know, incoherent, or their family members are incoherent, when they're on their deathbed, when they wish they had done it before, and it's not. So take care of it. Give my office a call, give you a free consultation, let you know what can be done, and so forth, and the costs, and then we go from there. So if you like the video, click like, subscribe, and more on the coming videos.